Hi, Cat Floss. Cat Floss. Cat Floss. I wasn't really prepared. Oh, it looks a bit blurry. It's an early morning meeting, and I'm just going to post this because I was talking to a nice fella, and I was trying to explain to him he's been in a common law group for more than 10 years, and well, not really a common law group. He's been researching all of his own law and trying to figure out how he can get into the courts. And I have had some experience and gotten into the courts all the way to Supreme level, and my cases have been documented into the New Zealand Law Institute. Now, some of you won't know exactly what my cases are, but it's just basically under the 1688 Bill of Rights, or the 1688 Will and Mary of England. England, Scotland, Ireland, New Zealand, and Australia come under the protections of got my pajamas on, of the 1688 Will and Mary, or now called the Bill of Rights. Now, I want in that a lot of people don't know that is your common law. That is your written common law right there, and from that, the greatest thing of it was that you were going to be permitted to enter the court and call any ministers or prime ministers into the court to hold them to account to the laws and the bills that they're making over you. Now, that was the difference between when the religious organisations ran the world and the Pope ran the world, that they said that if you want to get to God, you have to go through us. You have to go through your church leader. Your church leader will then contact us if your church leader thinks that you're worthy of us, is what had happened. But this one said that no, we can go directly to God. We get to go directly to God when they're writing bills and when they're writing all these laws that we have to follow, but all the bills that we have to pay every single time they pass a bill. They don't pass laws. Every single time they pass a bill, you have to pay for it. And so what they said was, even though you're going to have to pay all the bills, we're going to give you the right to go to the court and call parliamentarians to the court to challenge any bills that you don't think are protective of you. All right. So I said to the man, he's saying he couldn't understand really everything what I was saying. So I said to him, the first thing you've got to do is go and read my cases. Now, I got thrown out of the first court, and then I appealed it, and in the appeals court ordered Prime Minister Ardern and Andrew Little ordered them to come to the court. And they said, if you don't come to the court, we will carry on this case without you, and you will not be entitled to any of the documents or any of the decisions that we make about you. So I did get a letter from the Crown Law to say that they will attend. So that is that case. Then they had asked me to pay fees. Well, under the 1688 Will and Mary, it says we have the right to petition the King, and we don't have to pay for it because we already pay them in the corporation that we own. We already pay them. So I had appealed that, and so then that had gone to the Supreme Court. And then when I got to Supreme Court, they asked me for another fee. So that case with Justice Brown is sat in Supreme Court. And then I appealed that second fee that they ordered me to pay. I lost that appeal, but they said you can still come back to challenge Justice Brown about the appeals court's fees. So that's all what's going on. Now, what I have been able to put, so then some other things went on. I won't go into it today, but So I wanted to show him, I explained to him how to go and look at my cases. You have to go to the first case and you have to read all of the things that got me struck out to know. And as it turns out, it was a good thing that I was struck out, because that put me onto an aeroplane that just sailed me all the way to the Supreme Court, and I was able to put all my grievances. Usually what I do is I put on the top of on the official pages, I write all of the relevant laws, and I don't deviate from that. But when I finish that, I then write a letter to the judge at the bottom with all of my earthly grievances, all of my slavery grievances I put on the bottom, and I tell them all the things that I'm disappointed about what the governor's doing to us. Now that goes to the Governor General, and if you're putting in there to the King, it may even go all the way to the King of England. I don't know, but it might. So I'll just bring this in. I'll go to, I think I can just bring it in. So I'll bring this in here, and I'm going to show you how to, so all you do, this is for my friend. I won't use any names, but he's a nice old chappy. So here's for my friend. All you do is you Google Insixtus, Sixtus, and it's going to come up Sixtus versus Dern. So don't click that. And the reason why we don't want you to click that is because it will only take you to my first two cases, and it won't take you to my Supreme Court cases. So delete that, and then you put NZLII. I always go to NZLII because it has all the original documents that were ascended. So you click that, and you'll see here, New Zealand Legal Information Institute, NZLII. So if this Sixtus one doesn't come up on your search engine, you will be able to search New Zealand Legal Information Institute, NZLII. You click on that. So I have a click on there, and then you'll get all these laws here that have come up, and you go to the search engine. And as you see on mine, you'll see there Sixtus versus Dern, but I don't want to get that. If you get the Sixtus versus Dern here, so if you get that one, you can click on that. What you'll only see is my first three cases, 1, 2, and 3. And of those 3 cases, one of them was just a technicality that the judge had corrected, but the other 2 were the cases, all right? But if you, so go back, but if you search only Sixtus, there you'll see all my cases. And then you'll also see my German Settlers Naturalisation Act and ordinances. You'll also see the 1858 Naturalisation Act and ordinances. So you'll see all of that there, okay? So you can go to my first case, which is Sixtus versus Dern, and it's got here August, May, and this Sixtus first kid is not mine. Then it's got June, and here's my New Zealand Supreme Court of New Zealand ruling, which was on the 1st of February, okay? Now, if you go to the first one, which is August, May, March, April, May, June. So if you go to this one here, and then you'll see this is my, oh, actually, this is not the first one. This is the judgment of Brown. So actually, this was 2022, April, June, July. Oh, so you'd have to go June, January, February, March, April, May, June. You'd have to go to the May. Go to May first. So this is my first case, and then this is called the strikeout by the judgment of Cook J. You've got to read it very carefully. These were my prayers, and I am pleased to tell you, I'll tell you in another video, but the fourth prayer has already been answered, but I'll tell you in another video. But if you go on there and read it carefully, all right, what you'll see here is all the cases that they used to strike me out. The main cases, these are the ones that you've got to read, is the Inland Revenue versus Chesterfields, the Matheson versus Slevin. You've got to read those cases. And if you check here on the little 53 or the little 89, it shows you the section that they used against me to strike me out. But I would encourage you to read these laws in their entirety. And so click on all of these, so you can just click on them. Go on there, and it'll take you to that law, all of it. And so you can read. And then when you go there, you've got to click on all their stuff as well. So you've got to read these things. There's a lot of stuff in here, so you've got to read a lot of it. So that's just telling you about my cases and why I was struck out. You can see here that I called in Jacinda Ardern, Chris Farfoy, Andrew Little, Ashley Bloomfield. Chris Farfoy has resigned, Jacinda Ardern has resigned, and Ashley Bloomfield has resigned. We've still got Andrew Little left. Now, it may be that, no, I won't go into that. So that's just who I called in. If you go to the second one, this is the ruling of Judge Brown. And then the judgment of Judge Brown, where with the application to review the registrar's decision of declining a fee waiver, and he's given his reasons. And if you go, and then that one there has even got the Sixtus versus Dern case attached to it. And in this one, he said, he basically said, the naturalization of may bring, he called me a citizen. I said to him, I'm a subject. And he said I said to him, I'm a subject because of my German settlers. He said to me, you're not a subject, you're a citizen, so you pay. And so the battle here with him is whether I can claim my subject status or I'm a citizen. Then when I went to don't worry about this one. This one's just a technicality. Then if you go to the Supreme Court, and then this one here was the appeal of the registrar of the appeals court. And then you'll see my cases, Sixtus versus Dern 1161, which was the strikeout. Then you'll see Sixtus versus Dern 372. That was the judgment of Judge Brown, that they would not give me the fee waiver. And then this is the new one, and I did manage to get in there. Every time the judge will give me a little bit of what I write about. So I got this little bit in there. I feel like it was a win. The application for review of the Deputy Registrar's decision in this court canvasses a range of matters to support the proposition that the proposed appeal raises matters of genuine public interest. A consistent theme of the submissions is that the right to petition the King under the Bill of Rights 1688 imperial laws provides a right to petition without being subjected to fees and costs when petitioning the High Court on questions of law. So the judge declined the application for the fee waiver. However, this was the application for the fee waiver in Supreme Court against Justice Brown. And then Justice Allen, so this was done by Judge Alan France. But Judge Alan France, who I thought was very fair, then went on to say, the application for the review of fee waiver in the Supreme Court is dismissed. However, she said, if the applicant wishes to have the application for leave to appeal accepted for filing. This is talking about the appeal of Judge Brown from appeals court. The applicant must first pay the filing fee. So they've basically, Judge Ellen France has said, welcome, come on back to the Supreme Court, come on in and fight Judge Brown in the Supreme Court, but do your civil duty and pay your $1,000 to the Supreme Court, and we will let you come in and fight your case with Judge Brown. So that's how you do it. I'll just do a quick review for you. All right, so you go to your Google, you Google in Sixtus, NZLII, you click that, then you see the New Zealand Legal Information Institute, go ahead and click on that, get to your search engine, click in just Sixtus by itself, go to search, and then you'll see all my cases pop up here. If you want to, a little handy thing for you to go here, if you go to the Supreme Court of New Zealand, if you click on that bit underneath there, you'll see all the cases here of the every Supreme Court ruling for all of those years. And if you go to 2023, you'll see we are the first one in February of 2023. And all these cases will have things that are relevant to my case. So that is a very handy little thing that you can pop in here. And so you click on the May version first. Then if you go to the May version, it's just all about, if you're interested in law, that this is what you need to learn to do. And there is the judgment of Cook J called the strikeout. The most important things to read are the 4 prayers that I had put in. And then the important thing to read is the Inland Revenue versus Chesterfield. This has got a thing in it called the Manic Law. And that's how they're able to strike you out. And then Matheson versus Slevin, you can go and look at those laws. There's some other ones down here, Attorney General versus Arthur Taylor, and some other points. There are my grievances in there. And then after you've done that, you can go to the August version. Excuse me. That is the judgment of Brown J. Then you go to your Supreme Court, which is the judgment of Justice Allen. All right? So that's a pretty simple video to let you know what to do. I'm going to close the video. Now, when I go to the court with Judge Brown, which I'm going to be doing quite shortly, I'm all planning to go in for that, what I'll get with him is I get 15 minutes to speak to him about why I think that when we call parliamentarians to the court when there is a breach of the 1688 Bill of Rights, we are permitted by that 1688 Bill of Rights to call parliamentarians into the court to hold them to account, right? And I believe, and it says there that we can do it for free. So when I go to see Judge Brown, I get 15 minutes to talk with Judge Brown, and you can say a lot in 15 minutes if it's well planned. He gets 15 minutes to speak back to me. We both get 5 minutes. Oh, no. Then I get 5 minutes to rebut what he said. So that's a whole 35 minutes of court time. It's going to cost me $1,000, but I've had my cases put up. I believe I've got $1,000 worth of lawyers and judges, and I've got all those judges. I've had all those write-ups. So I believe it's well worth. Look, Tamati Wakanene, who is my spirit guide, Tamati Wakanene walked with my ancestors, and he's my spirit guide. He's there with me, and he's smiling. We've got Queen Elizabeth, and she's smiling, and Jesus, who is the 1688 are called the will of Jesus. He's smiling too. And we've also got Queen Victoria. She's smiling. So everybody's smiling because they know Kate Floss is in the court. I'll just quickly tell you one other thing that I did use to go into the court, which is very, very important as well for going into the court, is this one. You can Google in Declaratory Judgment Act, Declaratory Judgment Act 1908 NZLII. Declaratory Judgment Act 1908 NZLII, and you just click on there, and then it will come to the Declaratory Judgment Acts, which is part of the laws of New Zealand. This is a very, very important law for you, because it does say it's only like one page, or it's about 3 pages, but it does say there that where any person has done or desires to do any act, the validity, legality, or effect of which depends on the construction or validity of any legislation or any deed, will, or document of title, or any agreement made or evidenced by writing, or any memorandum or articles of association of any company or body corporate, or any instrument prescribing the powers of any company or body corporate, or where any person claims to have acquired any right under any such legislation, deed, will, document of title, agreement, memorandum, article, or instrument, or to be in any other manner interested in the construction. So you only have to be interested in the construction or the validity thereof of any of these laws, even of a title such as a Te Roha or a memorandum. Such person may apply to the High Court by an originating summons for a declaratory order determining any question as to the construction or the validity of such legislation, deed, will, document, agreement, memorandum, article, or instrument. So this is the most important tool that you're ever going to have in your tools to take to the court. And the other one is the 1688 Bill of Rights. Always type in NZL. The other one is the 1688 Bill of Rights, NZLII. Always type in NZLII. Always. And that will take you to the Bill of Rights 1688. And then you will have your original version as it is enacted. And then this one gives you the right to petition, that it is the right of the subjects. So we have to prove that we're subjects to petition the king, and all commitments, meaning all fees and prosecutions for such petitioning, are illegal. Here's your freedom of speech right here. And then levying of money, which forbids them from spending your money on their bits and pieces. Then there's also the most important one, for fines and forfeitures of particular persons being before conviction are illegal. This is about your land. They cannot forfeit your land. This is talking about a forfeiture of your land and your property without any conviction is illegal. That's the SNAs there. That's what you would use to fight those SNAs. You would use fighting against all this money that's being given only to ethnic people, only to refugees, only to Maori. That all comes under levying of money for another manner. They're not allowed to use the money for a particular person that does not include you. If it doesn't include you, they're basically stealing your money. Every 1 cent that they take of yours and they give it to a cause that does not include you, that is theft of your money, because you're not included in that. So that is a theft, and that comes under the levying of money. And that also, now we have our subjects' liberties to be allowed, and all ministers will be ordered to stand down. So that's when you go and get your declaration. I'll explain that later. I've done it in other videos, but not today. And then also they have got the limitations of the Crown, and for preventing all questions and divisions in this realm by reason of any pretended titles to the Crown, and for preserving a certainty in the succession thereof, in and upon. Now, this is how they govern us upon this law. They must govern in unity, peace, tranquility, and safety, with unity being the highest order. So they're not allowed to divide up organizations. So every organization has to be monies for all of us or not at all. So there can be no more of this stuff that they're doing for separate entities. That's called ruling by division. They're not allowed to rule diversely. It's forbidden. They must rule in unity, and currently the governments and the Maori entities, none of them are ruling in unity. They're all ruling by division, and that is illegal to their post. So that's about all I'm going to do. Kate Floss signing out. I'll try and make some more videos as I can for you. Got a smile here.